This is my response that I sent to Chris last night on the 7th of October. Hiya Chris. Good to hear from you. I trust you're in good health. Thank you for responding in relation to the emails I had sent Philippa. I trust you found the footage as alarming as I did, given the CSOs overstepping their boundaries and authority and harassing me for no reason. You are correct that those emails were referring to the 2 P.I.P.P tests, or Photography in Public Places tests, I conducted while in the area of Waitakere District Courthouse. However, the third visit was not without incident. There was no direct interaction, thus I was not harassed for a third time in a week. However, it would appear that the CSOs have chosen to close the glass doors to obstruct my camera view. Glass is not the best thing to use as a side note. Also, training them to shut the door correctly and not cause damage to the door will also be in order, it would seem, according to what I captured on my third visit.
And he goes, run, run. Better close those doors again. Doors aren't meant to be open, shut very often, are they? He's just closing them.
Even going so far as to point out to a member of the public that I was recording so he could come and question me.
I'm just doing some public photography, buddy. Oh, yeah. I've been here a couple of times in the last week and the guards have come out and barked orders at me and told me I can't record on the public sidewalk.
Oh yeah, on the sidewalk you can, but not on their premises.
Exactly. Never went past their boundary line. And they came out here and threatened to call the cops on me and all sorts of shit. So put a complaint to the building services manager, told them I was coming back today and make sure they don't come out and fuck with me again, basically. So, and footpath. But you know, the guard on Monday was telling me that they maintain the sidewalk. Really? They don't look after the rubbish bag very well. They don't maintain the bus stop.
It's the whole situation.
Which is what he did, the guy in the hoodie. Oh, you media or something. And it was straight after the guard closed the door, whispered something to the guy, and then wouldn't let him in. So, were they restricting people's access during open hours to the court? Perhaps. I am still contemplating whether to file a criminal harassment complaint against Waitakere District Court security officers for what is clearly unacceptable behaviour and classed as harassment under the Harassment Act 1997, Section 8. As to your preliminary point, you say you've watched the videos, correct? Did you not see where Philippa's email contact was supplied to me by Holly at the 0800 268787 call centre?
Security service manager you're after, or the Waitakere?
Whoever's in charge
Service
of the court
manager.
whoever's in charge of the court security officers.
Philippa. P-H,
I-L.
2 L's, P-H-I-L-L-I-P-A.
Yep.
Surname Chapman, C-H-A-P.
Yep. M-A-N.
M-A-N, that's right.
Cool. And email would be
The email is to...
philippa.chapman@justice.gov.nz?
That's right, that's her name.
Cool. Awesome. Okay. Thank you very much, Holly.
No problem at all. All right, thank you. You too. Bye.
When I asked for the person who was in charge of the CSOs, I didn't pick this address out of thin air, Chris. It was given to me by the Ministry of Justice when I stipulated what it was about. I would suggest that if Philippa is not the correct person to contact, that making sure this is corrected at the call centre to avoid me having no response. Of course, Philippa could have emailed me to inform me of this also. However, let's digress. Thank you for verifying that I was doing nothing unlawful or illegal by exercising my freedoms on the footpath. I am pleased the CSOs will be given corrective guidance to alter their correct position or their incorrect position. As for the apology, thank you and thanks to the Ministry. However, it is somewhat of no significance given the further contemptuous statements made later in the correspondence by you. Question 1. I am glad that you noted my question in relation to the media. However, the media is not obligated either to seek permission to record public building from the footpath. They may need to check with Auckland Transport if they cause some sort of obstruction, but nothing is required from Waitakere District Court as they are not stepping foot in their jurisdiction. Correct? I am already well aware of your belief that to record inside a courthouse requires permission from the building services manager or the like, along with your belief that the same permission must be sought from a Judge JP while inside a courtroom. However, that has nothing whatsoever to do with the 2 instances that caused myself to fear for my safety through the harassment I received from the court security officers that approached me on the public footpath on the 21st and 24th of September 2018. Question 2. I note that you have not addressed this harassment by the CSOs towards me. I further note that you have not addressed any of the questions posed in those emails, such as what section of the Privacy Act was the second harasser, the white, male, overweight court security officer, referring to. And no, I'm not editing that out either.
Referring to the section about third-party information.
Question 3. Was it acceptable for the first harasser, the small Maori CSO, or Chihuahua, to come out onto the public footpath, ask for my ID, ask my business, state false requirements, then fail to hold a civil conversation and then use the threat of police that can use force to have me move on, cause myself distress and alarm?
Yeah,
Who are you and what are you doing?
I'm filming the signs on your door at the
No,
moment.
I'm sorry, you have to have permission to do that.
By
Who have
who?
you got permission from?
By
From the
who?
court manager.
I'm on a
so
public
you-
sidewalk, yeah?
It
I'm
doesn't
not
matter,
in the
you're not
court.
filming public property. This is a courthouse, you need permission.
Courthouse is
Okay.
public property.
Are you going to argue with me? I can get the police to explain that to you, sir.
There's nothing to argue.
Okay, well then stop filming because there's public that come out and that's their privacy that needs to be protected.
You're aware
Are
there's
you
no...
going to argue with me, sir? Because I will...
I'm going to ask you a question.
No.
Are you aware there's no expectation of privacy in public?
Listen, there are people that are coming out of the court that do not wish to be filmed.
The public court.
Okay?
Correct.
Was it? Question 4. Was it acceptable for the second harasser to attempt to question my mental state or demean what he believed to be my comprehension of legislation?
It's the law.
Well, then you show me the law
And if you
because
read
I
more
can
than
show you...
just what you thought you understood, then you probably have a
Is
better
that right?
opinion of it.
How do you know what I've understood?
Well, you don't understand this, so it's clear.
How do I not understand it?
Yeah, look, we'll let the police...
Cool. Call the police and I'll have them educate you in public photography.
Question 5. Or acceptable for the second CSO to again cause me alarm distress, stating he was calling the police to handle me. Question 6. Was it acceptable that after 49 minutes waiting, no police arrived, implying the second CSO was lying about calling the cops, wasting approximately an hour of my time in the process? Question 7. As for making arrangements for people who are exiting a public building who do not want to be filmed, do you respect this wish inside the courthouse? Question 8. Or are you filming them also? Sounds somewhat hypocritical, no? There is no expectation of privacy in a public place or publicly accessible areas other than a public changing room or public toilet. That is the fact of the matter, unless you can provide evidence to the contrary. Furthermore, media are also acting in a commercial capacity and are governed by the Broadcasting Standards Authority, or BSA, as they are members. I am not. I make no revenue from YouTube and have not monetised nor will monetise my channel. I am simply a private man exercising my freedoms. As for you deeming the term used
Panicky little bitch.
panicky little bitch unacceptable, I believe this to be an accurate assessment. As I stated, she reminded me of a chihuahua running out and yapping. Acting like such would derive also that her being a female, acting like a dog, therefore, bitch, is, in my humble opinion, protected by New Zealand Bora 1990 Section 14, freedom of expression. As you know, quite acceptable. The commenters on the videos have used far worse terms to describe this woman, and they are free to do so. I do not censor free speech. You, Chris, seem to take issue with a man speaking freely. Perhaps some counselling could help you with this. Just a suggestion. Your request is denied in that respect. Do not be unreasonable. As for being treated with respect, if the CSOs that approached me had started with respect, opposed to having some delusion I was doing something that required permission, and spoken in a courteous manner, they would have received the same in return. As a member of the public, who they are supposed to serve and not obstruct, it would be expected that the CSOs are to be courteous and respectful from the get-go. This did not happen. Their authority was challenged, as they had none on the footpath. They were poorly informed, misinformed, or just plain ignorant of any legislation supporting their actions, and I had documentation, should it be needed, to satisfy any question as to the lawful activity I was conducting. So I agree, one must give respect to have it reciprocated, so perhaps that is another adjustment in the CSO's position that needs corrected. Question 9. I noted further that you have nothing to say about the CSOs following a member of the public challenging him to a fight. Is that acceptable to the Ministry of Justice?
Great footage, fellas. Disgraceful!
You state that I implied that you agreed with me with regards to recording in a public building, provided one acts lawfully. To note, 1. On May 11th at 3:33 p.m, you wrote, and I quote, "Secondly, the prohibition on recording is a civil matter, not criminal law matter. It is not of itself a criminal offence to record in violation of the prohibition. Rather, it engages the Ministry's right to ask you to leave as the person with lawful possession of the building." So they revert to the trespass, because you don't have to follow their conditions of entry, because it's not unlawful to do so. If you're standing there doing something perfectly lawful in a public place that goes against their conditions or prohibitions, it's still lawful. It just means that you don't agree with it because you think that's unreasonable. And I think them recording in a court building and asking me to not be able to record in a court building for my security, if not any other reason, is unreasonable. Which I interpreted to mean it is not an offence in and of itself to film in a publicly accessible areas inside the public building, even if conditions of entry state otherwise. And if one does not comply with the building's or corporation's policy, which is not law, you can revert to using civil trespass law to remove the non-compliant individual. However, no offence is created, and therefore it is not unlawful, just against the private policy which I am not subject to, as I am not an employee of the Ministry of Justice. Further to note, too, on April 20th at 3:46 p.m, you wrote, "The main difference between a public building and a private one is that there is an implied license to enter and remain in a public building for lawful purposes. For private property, there is only an implied license to go to the front door, unless they express otherwise, like put a no trespassing, nothing implied. However, as with a private building, the owner or person in lawful possession of a public building can impose conditions of entry. Unlike a private building, any conditions of entry to a public building must be reasonable, reasonableness being a requirement of all government decision making." Bullshit! If there's anything more unreasonable, it is government. They don't do anything reasonably. And their decision making? Really? Therefore, as you have expressed this in previous correspondence, I have implied nothing. Once expressed, there is nothing to be implied. So, Chris, you might want to check your own emails, because I didn't imply anything, you expressed it. Question 10. As my lawful purpose is seeking information and opinions of any kind in any form, as any conditions of entry to a public building must be reasonable, explain how exercising freedoms in a public building is unreasonable. Looking forward to that one, although I doubt, Chris, you're going to answer any of these questions. No offence would be committed, and the possessor of the building would have to use civil trespass to remove, obstruct and prohibit the individual exercising those freedoms affirmed. The Ministry can prohibit whatever it likes, so long as it is deemed reasonable. However, prohibiting me or any other individual's freedom to record, and in turn keeping those public servant capacities accountable and transparent, is deemed reasonable. And as the Ministry records the public in those areas under the guise of security, the Ministry cannot prohibit others that same freedom, given that any individual should also record any interaction with public servants for their own security, given the immunity those servants hide behind from any error or omission. No offence, breach or infringement is created by doing so, as it is not unlawful nor illegal. However, according to you, non-compliance is unlawful, which is incorrect. It is a pity you choose not to provide me with more detail about the legal basis on which the Ministry can prohibit people filming in the court building, if such exists. Perhaps, Chris, as you have the time to watch my videos, you could multitask and do it then. Until such time as you can, no such legal basis will be presumed to exist. As the onus probandi falls at your feet to back your statement, I look forward to such case law being provided. As for common law, possibly having a chat with Hurd of New Zealand Police Prosecutions North Shore, as he stated that New Zealand is not a common law country, on record, so you two have opposing views yet are both legally trained. Interesting. Maybe it's all just how each interprets and believes absent facts. I note that even though you have addressed the matter of filming in court buildings, which has no relevance whatsoever with relation to the behaviour of the two CSOs and their actions that caused harassment to me personally on two separate occasions, you have not addressed their demeaning or disrespectful approach to me on the footpath, as I did not go onto the court premises and stayed where I am aware I can be while exercising freedoms. Your information is also irrelevant. However, now that you have brought this bill to my attention, I will be discussing this with the local MP. And it is not only conflict with BORA, it also conflicts with rights as a party to proceedings to keep an independent record of any proceedings. See District Courts Access to Court Document Rules 2017, Rule 7.1b, as well as Rule 12e and Rule 12f of the District Court Access to Court Documents Rules 2017. Therefore, the Court Matters Bill, which is not passed yet or applicable, does not only conflict with New Zealand BORA, as Section 4 of New Zealand BORA states. I will be sure to inform the general public of this new and overstepping bill and gauge their reaction through responses. The whole purpose of a public court is for open and fair justice, yet the Ministry does everything it can to covet and be as least transparent as possible, through the ignorance of those they govern, not comprehending how or why. I will reiterate, the bill is not enacted and has no relevance, and due to you bringing this to my attention, albeit unsolicited, I will be giving this bill much more attention. Though it says nothing about sitting in a passenger seat filming from the road, that would be acceptable regardless, and my cameras have impressive zoom. So the ministry can attempt to covet what it likes, using an unreasonable expectation of privacy in public accessible areas all it likes. This will be given much more attention. There are no signs anywhere stating no recording. In fact, there are many signs informing the public that recording is in operation. There is a Ghostbuster type sign with a cell phone, which I translate to mean no cell phones on in the courtroom. However, the many staff and lawyers appear to wander all around the courthouse using their phones. With this Court Matters Bill, will everyone walking in the courts, including the footpath outside, be forced to turn off their cell phones? I think not. In fact, I have documented prosecutors using their phones inside courtrooms, but then there are different rules for those in the club, I suspect. Chris, you may want to look at Section 3 of the Court Matters Bill, which currently has no force or effect, and ask how strict the CSOs enforce this on the footpath outside and opposite the courthouse, especially when the specific act of using a camera does not cause any harm. Only cockroaches detest light. Perhaps that is why the Court Matters Bill has been written, in my humble opinion. Irrespective of what powers the courts or ministry may believe they have, the court of public opinion has far greater scope, reach and power. Put simply back, New Zealand BORA, or New Zealand Bill of Rights Act, may be subordinate if it is the only act conflicting with another. However, the Court Matters Bill conflicts with other enactments also, and nothing on a piece of paper governs mankind. Only persons should mankind wish to represent as such. Parliament is elected to serve, not in power to rule, and should learn its place. Finally, I am glad you note my practice of failure to respond notices at the bottom of the correspondence, stating facts that have happened and failing to respond as acceptance. Such statements may, in your opinion, not have any legal effect. This is a practice I have learnt from dealing with government agencies, as they do this to encourage responses or to gain acquiescence by silence. This practice does, however, more times than not, get a response and puts the recipients of such notices in the mindset more to respond than ignore. I note that you have responded within the specific time frame given to Philippa. Thanks. Yet my first email had no such response and was ignored, as no failure to respond notice was included. Therefore, even though you would believe it has no legal effect, it gets responses as opposed to silence. If you wish to make your point that it doesn't work, you should not have responded until after the time frame had elapsed. It gives the impression of you being disingenuous and somewhat hypocritical. I won't bother putting a failure to respond notice on this correspondence, as I did not ask for your legal advice in the first instance, and have no wish to hear from you in response. In fact, I would prefer you didn't bother or harass me at all. If the ministry's staff were trained properly in the first place and didn't harass people on footpaths, none of this would have happened. A couple more videos related to Waitakere District Court are due to be published later today. I will send you a link, which I did. Perhaps while you're watching them, you could source that case law you believe exists. And of course, this correspondence will also be published for maximum transparency and accountability in accordance with New Zealand BORA Section 14. Please answer the questions if within your ability. I may contact the police clearly, as the two occasions of harassment committed by the Ministry of Justice CSOs on the 21st and 24th of September have not been addressed, and how the police respond will also be documented and posted. Enjoy your day. Me. So, that's my response to him. Haven't got a response from don't want a response from you, Chris, unless you're going to answer my questions. If you're going to start bleating on about law that isn't passed yet, and law that has no force or effect, or what your beliefs are, mate, you can tell me you believe in Santa Claus, fairy tales, and unicorns. You're welcome to believe it. Unless you can show me some facts, it's just a belief, like everything else without factual evidence to back it. Bye.